Happy Halloween, Brandon. How are you?
Good. How are you?
I'm doing great. I had a question. Uh, During 2020, in the second quarter, Alan paid me $2 for working 1,000 hours. Will he be able to get the earned credit for this?
He would be able to claim 50% of that $2 and get $1 back as a credit, but I think he might have some other issues with maybe minimum wage and some of the worker protections that would apply in that employment situation.
Somebody said that I wasn't personable or something like that.
You seem pretty friendly to me.
Oh, let's go out. What are you doing tonight?
I'll have to check with my wife on that one.
Okay. All right. Well, unfortunately, we have to start the show. It gets worse from here. All right. Welcome, everyone, to our Halloween celebration of the ghoulish situation going on with the ERC crisis. I am Alan Gassman, and this is Brandon Ketron, and we have about 2 hours of material to cover in 30 minutes. The big story is that the ERC, which was a very generous, very taxpayer-friendly method of getting money out to employers, small employers, during the COVID crisis, had some gray areas and also apparently not a lot of accountability with reference to some of the advisors who were giving advice under the ERC program. Traditionally, tax advice and tax filing comes from certified public accountants and enrolled agents and organized companies who, believe it or not, intend to follow the law. And in the tax law, there are pure areas where things are absolutely safe and clear. There are gray areas where some taxpayers voluntarily venture, where things are not so clear, but they are what we would call defendable, or there is substantial authority for positions taken. And then there is the dark gray to black area, which in some cultures is, well, I'll fib a little here and fib a little there and not pay the full amount of taxes and hopefully get away with it. When I started practicing law in 1984, there was some of that. In 2021, there was almost none of that, or very, very little of that. And then along comes the ERC and the ability to say, well, I did have this, I did have that, big check. And a lot of advisors who were not CPAs, enrolled agents, or law firms, but were business people who figured out that they could advertise, call people, help people get big money for ERC, and take a piece of it. So you have a lot of naive taxpayers and some not well meaning tax advisors. You have a little bit of greed, and you have a lot of a big mess. And when you've crossed that line, whether you crossed the line voluntarily or you crossed the line because someone got you confused, you're now involved in a criminal offense. And when you're involved with a criminal offense, you have to be very, very careful, because when the government comes after the sharks, they throw the nets and they do accidentally get a few dolphins. And if you're one of those dolphins who has been swimming with the sharks, you have to be extra careful. You have to communicate only under the attorney-client privilege in many situations. And you may have to tag the IRS before the IRS tags you. The long-standing methodology of the IRS has been that if a taxpayer commits a criminal offense as to tax filing and comes and tells us about it before we've questioned the matter, before there's an audit, before we would otherwise know about it, then we may impose civil penalties, but not criminal penalties. Now, the pronouncement that Brandon's going to talk about talks about civil penalties, but doesn't talk about the criminal implications. And when you get involved with criminal implications, you need to assume that the IRS is going to find these ne'er-do-well preparers, sit them down, and say, do you want to go to jail for 3 years or a year? Well, I'd prefer a year. Okay, well, give us your client list and be prepared to help us implicate your clients, as many as possible, and we will give you a lighter sentence. And at that point, they may even put a wire, that's a recording device, on that advisor and get a court order allowing that advisor to go meet with some clients to talk about the crime, get it tape recorded, and then use that to convict otherwise honest business people who just fell into the wrong place at the wrong time. So I'm going to take my crown off now. Still Halloween. I'm going to turn this over to Brandon, who's a lot smarter than I am, and we're going to spend the next 25 minutes telling you what we think you need to know if you're in this soup, how you're going to find out if you're in this soup, and what to do if you're an advisor helping others in this soup. Go ahead, Brandon.
Yeah, so all great points, Alan. I think that was excellent background as to, what's going on. I'm sure many of you have seen the advertisements that have been on TV, saying, hey, come and get your free tax credit from the employee retention credit up to $26,000 an employee. And many people have, reached out to those types of firms who haven't done a great job of representing the actual taxpayer and are really self-interested in getting these things on a contingency fee. So a couple of advertisements here before we get going into the detail. We're going to be doing a lot longer webinar on this. It's a 90-minute webinar for Lineberg Services. You can register for that webinar here. It is not a free webinar, it is paid, but we'd be glad to have you there for that. Alan will be presenting on the Corporate Transparency Act this Saturday. Very interesting topic that's coming through the pipeline here as to some disclosures that are going to have to be made from entities. So tune in to find out what that's about. And these are some upcoming events as well. So going back to our chart, many of you might have seen this before, the 30,000 foot view of all the CARES Act support programs. So this was basically all of the COVID relief programs that were offered in 2020, in 2021. Many of them interact with the others. There's reports that have to be filed saying where you got the money from, how you spent it. So this chart just provides an overview of that. We're going to focus mostly on the employee retention credit. But just to briefly mention kind of some background of that actual credit, how it works, how you're supposed to qualify. So for 2020, there are two ways to qualify. Number one, you had a 50% decrease in your revenue in one quarter when comparing that quarter to the same quarter in 2019. So you look at your third quarter of 2020, you had $100,000 of receipts in 2019. In 2020, you only had $40,000 of receipts. That would qualify you. So that test has been not really misabused. It's a pretty straightforward math test, right? You look at your tax returns, you look at the receipts, and see if you qualify or not. The suspension of the business test. This is one that is the big gray area, right? Because it's subjective. It's not really any true test. It's, was there a government order that caused your business to either be fully or partially suspended for any period of time in 2020 or in 2021? if you had that case, then you could qualify for the credit. Now, where this got kind of confused is a lot of these promoters came up with these generalized statements that such and such order impacted the business, impacted supply chains, caused me to close, which applied for a lot of people, but for others, it didn't. The order didn't impact them, or maybe there wasn't even a government order. Maybe it was just they voluntarily shut down. That doesn't qualify you. And that's where a lot of these people are getting into trouble, where a promoter of these programs getting a 15, 20, up to 30% contingency fee on claims have used this suspension of the business test to qualify taxpayers for the credit, when really the government order didn't impact them in any way. Now, for 2021, the same two tests apply, except the revenue test is much easier to meet. It only requires a 20% reduction, so you could qualify that way, and then you still had the suspension of the business test. So that's the qualification. That's the only two ways you can qualify. And we have some slides in more detail on that we won't have time to go through today, but they're in the materials for your reference, so you can look at those. Now, a lot of confusion related with the PPP program when the ERC. Whenever you got a PPP loan, you could also get the ERC, but you just can't use the same wages to count for both programs. So if you used a wage to count towards your PPP loan forgiveness, you can't also get an employee retention credit for that. So again, a lot of these promoters that got the credit didn't pay attention to any of that, looked at the wages, total wages paid, not taking into account whether or not those wages were used for forgiveness, and claimed the ERC on the full amount of wages paid, which may not be correct. So that stuff needs to be verified if you used one of these promoters and didn't have your tax professional, someone qualified to look at these things. The other aspect of this that caught a lot of people by surprise is, yes, the receipt of the employee retention credit was tax-free. You didn't have to pay income tax on its receipt, but it reduces the wage deduction that you got for paying those wages. So if you had $100,000 of wages, got a $50,000 employee retention credit, you can only deduct $50,000 of wages. So in a way, it makes the receipt of the ERC taxable. And these promoters, most of them didn't tell clients about this. And then when they met with their CPA to file their tax returns, they said, oh yeah, I got a retention credit. And the CPA says, well, now we got to go back and amend our 2020-21 tax returns, reducing our expenses to the extent we receive the credit. And now you owe additional taxes because of that loss of the deduction. So that's another thing that needs to be discussed with a tax professional if you got the credit, whether or not you appropriately accounted for it. Now, it didn't have to be spent on anything in particular, so you don't have to worry about that. It was just a reimbursement for wages that were actually paid by the company. But all these rules, whether or not you qualified, whether you accounted for it correctly with PPP, whether or not you amended returns, all need to be considered and looked at. The ERC is still available. Let's point that out, that the deadline is the filing for the Form 941, which is your payroll tax return. And that's for 2020 wages. You have up until April 15th of 2024 to file. For 2021 wages, you have up until April 15th of 2025 to file. We'll get to this in a minute, but the IRS is not processing new claims as of September 14th, but you can still file new claims. There's nothing that prevents you from filing it. They're just not processing claims until they get caught up and get some of these potential bad actors handled and make sure they're processing appropriate claims and not just fraudulent claims or claims that weren't really looked at closely. So Alan, any thoughts on any of that so far?
Okay, so if I filed an ERC claim, I have to amend my income tax return to reduce the deduction for the wages that I got the credit on?
That's right, yep.
And what's the deadline for amending the return?
So there's a 3-year statute of limitations, right? So, generally you can only amend a return 3 years after it's been filed. So, whether or not we don't really know what the actual rule is for when you are required to amend it. We're encouraged to tell you to amend that return and appropriately account for it. But there hasn't been any, pronouncements by the IRS as to what the actual deadline is for amending those returns.
And is there a circumstance where if you take the ERC, you have to pay back part of your PPP loan?
No, there's no circumstance for that. You just can't count the same wages twice. So if you got, a PPP loan and use 30,000 of wages to, count towards the forgiveness of that PPP loan, you can't also count that $30,000 of wages towards your ERC credit. So you have to match them up between the two. So it could be a case where, either a portion of the PPP loan wasn't forgivable because you got the ERC credit on that, or you should return the ERC credit because you used those same wages towards PPP forgiveness. So you just got to make sure no wages are counted twice towards the same programs.
Now, many medical practices and related businesses received HHS provider relief loans. Do those interact somehow to impact how the ERC was to work for them?
There was some, you had to account for how you use those provider relief funds, but as far as whether or not, wages overlapped or not, there was no real interaction between those programs. You just had to, account for how the provider relief funds were used. And, a lot of people missed the deadline for reporting on those and had to return funds. So if you're one of those that got the provider relief funds, and I think most of the deadlines have now passed for all the different phases, but make sure you submitted those reports accounting for how those funds were spent.
And the ERC is not impacted by and does not impact the EIDL loan program, correct?
It is not, right. The only thing that would come into play maybe is if you actually had the substantial economic injury to qualify for the EIDL loan. If you got a large ERC payment, that does probably impact whether or not now you still have a sufficient economic injury to really need the EIDL loan.
How do you remember all of this?
Spent lots of time in 2020 and 21 looking at all these rules. So, and picking back up on it again now with clients coming in with questions, with some of these latest pronouncements by the IRS.
Right. Okay. What's next?
So 2 other programs, I won't go through them in any detail here, but for shuttered venues, movie theaters, concert, music halls, these grants were available for them. And then restaurants also got a special fund allocated towards them. And some of the rules here are outlined. Again, there's some interaction between the two, but those are kind of outlined there on the slides. So again, just to repeat what the ERC is, it's a tax credit with wages paid to your employees during the pandemic, starting around March 12th, I believe, of 2020, all the way through the end of September 30th, 2021. You can get this tax credit for almost all businesses if you qualify. The ways you qualify, you have to have the revenue reduction, 50% in 2020, 20% in 2021. And that's comparing quarters against each other. So your 2020 quarter compared to your 2019 quarter, same quarters. And then for 21, it would be the 21 quarter, again, compared to the 2019 quarter. For 2020, you could get up to 50% on $10,000 of wages per employee for the entire year. So just one $5,000 credit per employee. For 21, it increased to 70% of $10,000 of wages per employee, but per quarter. So you had 3 quarters available in 21 to get this credit. So when you combine all that together, that's up to $26,000 per employee that you can get. So you can see this can add up pretty quickly, and a lot of businesses got millions of dollars through this program, and appropriately so if they qualified. Others stretched the rules a little bit and didn't necessarily qualify. There's more detail here on the rules, but I wanted to get to some of the IRS warnings that came out just to talk through those and then some of the recent procedures that were impacted or that were enacted for those that maybe got the money and now need to return it, now realizing they don't qualify. So the first warning really came out in March of 23, where the commissioner of the IRS published this, said, hey, we're starting to hear wind of these promoters that are pushing ineligible people to file. You know, you are subject to criminal investigation if you do this. You know, you don't want to have to repay the money. And there's also civil tax penalties involved with that, as you can see on the bottom, and along with interest. So not only do you get the civil penalties, but you have to pay interest on the amounts you received if you got the money improperly. Then May 25th, another warning was published here, again, reminding people that there's requirements for this. You need to make sure that these requirements are being followed. They put it on the Dirty Dozen list, which are the 12 biggest tax scams of the year. So the ERC made that list. And another nugget here that I thought was interesting. So they gave some warning signs. They gave some what you should do as a taxpayer. And these are on the slides here. You can read through those. But I thought this was interesting in this September 14th warning, where they actually placed a moratorium on the program, said we're no longer processing new claims through the end of the year because they're going to shift their focus to auditing. They're going to shift their focus on putting appropriate people to govern this to make sure we're not issuing refunds to ineligible taxpayers. But here on the bottom here, there was over $2.8 billion of fraudulent employee retention credit claims. That number just is, it seems very high to me, but not surprising, as you know, because a lot of these promoters just had blanket statements that they filed for these. And then there's been 15 federally charged cases so far, with the average sentence being 21 months. So there are people going to jail. This is not just a empty threat. You know, they're actually criminally investigating these things. So we need to make sure that we qualify. So Alan, if you got this credit, you know, and now you're wondering, what should I do? What, you know, obviously go talk to an attorney, but I think it's also important to mention that you can't just have a conversation with your attorney and your CPA and your financial advisor all on the line, because that impacts privilege. So how should people be communicating with their attorney and CPA to make sure we keep the privilege in place?
Right. So while state law says that any conversation in Florida that I have with my CPA stays confidential, and the IRS law says that a conversation I have with my CPA about normal civil things remains confidential, there is no federal law privilege for conversations with my CPA. So if I end up in bankruptcy, or I end up being federally charged with a crime, they're going to be able to see what my CPA and I spoke about. And investigators will use any and all information and evidence they can find to attempt to decide whether to convict somebody. So what I'm going to do if I'm in this soup, as I called it, is I want to hire a lawyer who is familiar with this area, or is at least familiar with tax law in general. And I want to make sure that this lawyer is my lawyer, not my return preparer's lawyer, not my CPA's lawyer, not the lawyer for necessarily for other people who got involved in this situation. Preferably, this is my lawyer and my lawyer alone. I retain her, which means that we enter into an agreement where it's clear that she is my lawyer for purposes of helping me with this. That may be a formal agreement. It may just be an email. And then my communications with that lawyer are privileged, not obtainable by the IRS or criminal investigators, unless the lawyer helps me commit a fraud or commit a crime under the crime fraud exception. Now, that lawyer may well hire an accountant or a CPA firm to look at the situation, to advise the lawyer as to what's legal and what's not legal and what the actual numbers are. That would not be my CPA firm who filed the return or who prepared the ERC return. It would be a separate independent CPA firm, and they are seen as being an arm of the lawyer to keep it under the attorney-client privilege. Once that CPA firm, which is hired under what's called a Covell letter, because there was a person named Mr. Covell whose lawyer hired a CPA and the IRS could not get into the communications. So once that CPA firm hired by my lawyer and my lawyer decide what I should do, then I'm probably going to go to another firm, maybe my original CPA firm, maybe another one, and have them actually file the return. Because a CPA firm that files a tax return no longer has this privilege. Was that succinct enough?
Yeah, no, I think that was perfect. That's exactly what we're looking for, and just to making sure, you know, that we're capturing privilege the best that we can. So going on to the next part here, you know, after you have those conversations, you find out if you're eligible or not with the attorney, and they say, nope, don't think you are eligible. You know, what can we do at that point? Well, if you're in the situation where, you know, you want to withdraw your claim, the IRS has just recently announced last week the process for that. Now, right now, it only applies in certain situations, so you have to meet certain requirements. Number one is that you made the claim on the 941, which most taxpayers have. You made no other adjustments with that return, which I think most taxpayers would qualify for. You want to withdraw the entire amount of your claim. So if it's a situation where you had a math error, maybe you didn't take into account the PPP loan funds, then that wouldn't work necessarily for this. You'd have to do another procedure, which I would follow these same rules and just submit it the same way with a note on it that this is why you're amending your return to correct a math error. But if you want to withdraw the entire amount, you can certainly follow this procedure, but they haven't published guidance on withdrawing just a portion yet. Number four, you haven't received payment on your claim, or you've received it, but you haven't cashed the check. So again, this is if you've received the money, put the money in the account, then you don't have a procedure yet to withdraw that or repay it. We are expected to get that guidance soon. They've indicated that in some of the announcements. So I would just hold off and, you know, keep the money in the bank for now, maybe segregate it into a separate account, wait till we get these procedures and proceed from there. Again, the notice also noted here that it is, while you return the claim with these procedures, you're not going to be subject to civil or interest payments on the claim, but it will not exempt you from criminal investigation and prosecution. So you got to be kind of careful about how you go about this. I think most honest taxpayers that fell victim to these promoter claims aren't going to have any issues. They're going to go after the promoters versus the taxpayers. But if you knowingly filed this, knowing you didn't get it, then that's where you could run into some issues. So 3 situations that apply, 3 different procedures, depending on what type of situation you're in. If you haven't received a refund yet, you've just filed the returns and you're not under audit, that's one situation. If you're under audit, that's a different situation. And then the third situation is you filed, you got the check, but you just held on to it, you didn't deposit it yet. Now, the procedures are outlined here on the slides, but generally what we have to do is we take a copy of the return with the claim that we wish to withdraw. We write in the left margin withdrawn, you sign it, and then you fax it to a specific phone number that the IRS has set up to receive these claims. So the phone number is here, 855-738-7609. That's your withdrawal request. And then there's a sample there on the slides of what this actually looks like. White withdrawn in the left margin, you sign it in the right, you date it, and fax that to the ERC fax line, and wait for the IRS to process that. Now, if you are under audit, you communicate this with the professional that's been assigned to you, and you submit the withdrawal process through the IRS agent that is auditing your claim. If you've received the check, you can do the same thing. You might fill out the form the exact same way, except you just clip the check on the form and you mail it to an address that the IRS has provided to receive these types of claims. And it's here on slide 31 to the Cincinnati Refund Inquiry Unit. You just clip your check and you don't endorse it. You write void on the endorsement section and send that check back to the IRS. Making sure we're sending this with tracking so we know the IRS has received it. I'm sure they're going to get a lot of these types of claims, so we want to make sure that we have kind of proof that we did send it and it was received by the IRS. They're supposed to send you back a letter acknowledging receipt and telling you whether or not the claim has been withdrawn. So if you don't get that within a certain period of time, you might just want to follow up on the matter and make sure you do finally get that withdrawal notification if you intend to withdraw the claim.
Maybe a good idea to take a picture of that withdrawal application, send it by certified mail, return receipt requested to the right office of the IRS to prove that you filed it. I think we're going to have all of our clients who do that to make sure that we have absolute proof that it got filed, not having it lost somewhere on the internet. So Brandon, we're out of time here. Is there anything you want to mention or any question you want to answer? Otherwise, we'll just be so much smarter on Thursday when we do this for 90 minutes.
Yeah, so I see one good question here. It asks us if we also need to amend 1040s for shareholders of S corporations and partnerships. And I think the answer is yes, because your K1 is going to change. You're going to amend the partnership and S corp return to reduce your wage deduction, which then impacts the K1 items that were sent to the shareholders, which requires you to amend their return. So yeah, it is a bit of a process there. And the only way you can do that is amending returns. There's no shortcut. That's been in the IRS announcements as well. Here's if I have a legitimate ERC for a client that has not yet been filed, should we hold or mail now? I would go ahead and mail it now. I don't see any reason why not to. So you get in before the deadline. You don't want to wait until March 15th and send that in right at the deadline. I'd go ahead and do that now. And then another question, does this nonprofit organization have to amend their returns? And I think the answer is yes. You still have to amend your wage deduction on those nonprofit returns that might impact business taxable income or other issues with the nonprofit. So yeah, they're still subject to these same rules. And then recording will be available. That should come out shortly after this. You'll get a link with the slides as well with the recording. I guess a couple of hours.
So for the advisors, as you may know, the Treasury regulations tell us that we must recommend to a client that they amend a return when they know they filed a return and they didn't intend for it to be wrong, but it was wrong, right? We recommend that they amend the return, but then the Treasury regulations do not require a taxpayer to amend a return if at the time they filed the return, they thought it was accurate. So there's going to be a lot of people saying, well, do I go ahead and amend the return and do the right thing and give the government back $34,900, or do I take my chances and just leave it as it was? Well, first of all, you've got to determine whether these ERC rules do not require an amendment or they do, whether they fall into these Treasury regulations I was just mentioning. Then you have to think about the risk of being a criminal defendant if you don't do this and get the money back. And then finally, how about pursuing that tax return preparer who told you that this was okay? Maybe that tax return preparer has malpractice insurance and you want to be the first in line to file a claim. In many states, you only have 2 years to go after a professional for professional malpractice. There are statutes of limitations that apply. It will be a shame when people give money back and are not able to recoup what they paid to the advisors who put them into this situation. Brandon, one last thing, and briefly, what is the situation if I had relatives of the company I own working? I mean, I had my relatives, I own the company, and I had my relatives working there. There was a gray area as to whether you could apply for wages, the credit on wages of your relative. You and I thought you could, and I think the IRS read the statute and thought you couldn't. Do you recall where we are with that?
Yeah, so there was always the rule that you couldn't get the credit on wages paid to relatives. That's your brothers and sisters, sons, nieces, nephews, etc. What was unclear is whether or not you could claim the credit on your own wages, because the FAQ issued said, you can't get the credit on these individuals, but they didn't list anywhere where the owner or the owner's spouse was one of those prohibited people. Well, they came out in a roundabout way and said, because of some of the way the attribution rules work, if you have a relative, we're going to treat your relative as owning the company, and then they can't pay a wage to you as the owner, so as the wages of the owner don't count either. Very confusing, but essentially what the IRS says is you can't get a credit for your wage or your spouse's wage. And a lot of people claim that, and turns out you weren't supposed to. So that would be a situation where now you're looking at returning a partial portion of that ERC payment received, maybe amending returns to reflect that return of the money. So yeah, that's one that's a little fuzzy, but I think the rules work out where you weren't supposed to claim those wages. Now, whether you return those or not is up to you, and you should discuss that with your attorney. But yeah, the technical rules are that those are supposed to go back.
All right, so heading back to Halloween, thank you very much for joining us. We will keep you posted periodically in our Thursday report. Have a fantastic rest of your day. If you signed up for this webinar, then you will receive a copy of it by email that you'll be able to click on and watch it or forward it to your friends. You should have that in the next 2 to 3 hours. And we will also post this on YouTube. If you Google Gassman YouTube, it should come right up in about 3 hours. Thanks again, Brandon. Really appreciate you doing all the heavy lifting, and I hope everyone has a great Halloween.